in drafting a plate under CPC. Thank you, and over to you, sir.
Thank you, Coordinator. Just a few minutes before, we witnessed this year's full moon eclipse, a rare celestial moment reminding us that even when light appears obscured, it is never extinguished. In the same spirit, may each one of you rise above every obstacle, overcome every shadow of doubt, and march forward with clarity, confidence, and resolute determination towards your goals. Good evening and welcome to this workshop focused on drafting plaint under CPC. Let me begin with a simple question. Am I audible properly to you all? Am I audible?
Yes, sir, you're audible.
Okay. My question is, can a legally strong case fail only because of weak drafting? I'll just have 2-3 quick responses.
Yes, sir.
Anybody who may say no? I feel and think that everybody in audience is of the view that a legally strong case can fail if the drafting is weak. Yes, it is, because courts do not decide grievances, courts decide pleaded disputes. Remember, the courts do not decide grievances, they decide pleaded disputes. Sympathy, assumptions, or moral outrage. Judicial power operates strictly within the boundaries created by pleadings. If a fact is not pleaded, it does not exist for the court. That is why the plaint is not just a paperwork. It is the constitutional gateway to civil adjudication. Gateway to civil adjudication. Therefore, we are trying to understand the drafting as a discipline of legal architecture. We begin with the Code of Civil Procedure 1908. Section 26 provides that every suit shall be instituted by the presentation of a plaint or in such other manner as may be prescribed. The Section 26 thus lays down the importance of plaint, it being the backbone of the suit, but it has not been defined. When we talk of Section 26, it provides 3 immediate consequences. 3 immediate consequences you may note. A civil suit begins only with a plaint. Without a plaint, jurisdiction is not triggered. The plaint activates judicial machinery so far as the civil jurisdiction is concerned. The concept of pleadings is very well defined or described under CPC. In civil procedure, pleadings are not formalities, they are jurisdictional instruments. Jurisdictional instruments. Remember, the question that comes to my mind is, what are pleadings? Order 6, Rule 1, CPC provides that pleadings shall mean plaint or written statement. So Order 6, Rule 1 CPC prescribes the limits of pleadings. The pleadings comprise of plaint and written statement. Then what is the purpose of pleadings? They have a purpose. And what that purpose is? To inform the opposite party. The most important purpose is to inform the opposite party of the dispute which has been raised by the plaintiff against them. Next is to narrow down controversy. Since we have to travel within the boundaries of pleadings, therefore, it narrows down the controversies. It also prevents surprises. Everything is there on pleadings. Nothing can be put by surprise in the back of the back. And it also defines a scope of trial. Order 4, Rule 1 CPC. It's important to turn to now. It clarifies that the suit is instituted by presenting a plaint and that the plaint must comply with Order 6 and 7. If you read Section 26, conjointly with Orders 4, Rule 1, Order 6, and Order 7, so you will just see the chain and procedural gateway. Section 26, Order 4, Order 6, Order 7. You must have noticed that I have referred to Section 26 and various orders. Do we have any idea about the concept of section and difference between sections and orders? For conceptual clarity, before proceeding further, we must know what is section, what is a rule, or what is order. You may know that CPC consists of 158 sections, and sections form the main body of the Civil Procedure Code. 51 orders and various rules in the first schedule. Each has a distinct function, authority, and interpretive importance. The sections are substantive and foundational provisions of the code. Substantive and foundational provisions of the code, and they form the body of the code. They lay down general principles, define jurisdictional scope, confer powers on courts, establish legal doctrines, and provide overriding authority. The sections are broad in language, foundational in character, declaratory of legal principles, and substantive in effect. The sections thus provide the skeleton of the code. Sections are not procedural steps, but foundational doctrines. The orders and rules form the procedural machinery. Orders and rules implement these principles step by step. Institution of suit, pleadings, evidence, judgment, appeal, execution. If I simplify these two sections and orders, then I may say that sections express procedural philosophy, orders express procedural mechanics. If conflicts arise between section and orders, sections prevail. Coming back to plaint and pleadings. It is doctrinally significant to note at the outset that the Code of Civil Procedure does not expressly define the term plaint. Instead of offering an abstract definition, the code regulates its structure and content under Order 7. The legislative technique is deliberate in the sense historically the concept of plaint was very well understood. in civil procedure as the formal written statement by which a civil claim is initiated before the court. Rather than freezing its meaning in rigid language, the code adopts a functional approach describing what a plaint must contain instead of narrowing definition what it is. This avoids interpretative rigidity and allows procedural flexibility. Jurisprudentially understood, a plaint is the formal written statement presented to a competent civil court containing material facts, constituting the cause of action and jurisdictional foundation and the specific reliefs claimed, by which a civil suit initiated. So this may mean the definition of the plaint. Plaint, if we describe in the light of the various provisions of CPC, would mean that it is a formal written statement present to a court of competent jurisdiction containing material facts, cause of action, and jurisdictional foundation with specific reliefs which a particular party want, for which the suit is initiated or instituted. Thus, its meaning is not derived from a statutory definition, but from its procedural functions. It is the juridical instrument that activates civil adjudication. It is thus a juridical instrument that activates civil jurisdiction. Order 6, Rule 1 defines pleadings as plaint or written statement. The core principle lies in Rule 2, which prescribes pleadings shall contain material facts and not evidence. The question thus is, what the material facts are? Material facts are those essential facts which must be proved to establish the cause of action against the opposite party. Remove one essential element and the case falls. If you want that the case should not collapse for want of material fact, you must, as a legal professional, must cull out the real facts, the essential facts, and enumerate every such essential fact in the plaint. I said that Order 6, Rule 2 mandates that pleadings shall contain material facts and not evidence. So I just discussed what the material facts are. Material facts are those essential facts which must be proved to establish the cause of action against the opposite party. Then what is evidence? And what is the difference between evidence and material facts? Material facts, as I said, are those facts which are to be essentially proved in order to establish the cause of action against the opposite party or the defendant. And evidence is what? Evidence is that what proves those facts. And what if we need to prove those facts, essential facts which we have enumerated and included in the plaint, if we prove that, it is evidence. As I said that they narrow down the boundaries or the dispute, they prescribe the limits of the dispute. Therefore, failure to plead material facts cannot be cured by evidence. Remember, you cannot travel beyond the pleadings. Even if you have led some evidence, it will not be considered if there is no fact in regard thereto in the plaint or the written statement. Now we enter the autonomy or the anatomy of the plaint. Order 7 Rule 1 mandates that the plaint must contain following specific particulars. 1. Name of the court before whom you are going to present the plaint. The next is the description of the parties, description of the person who is initiating or instituting suit, and also the name and description of the parties against whom the suit is to be instituted. Then comes facts constituting cause of action and when it arose. Facts constituting cause of action and when it arose. Both are very important. Facts constituting cause of action means the material facts, and when it arose means when the infraction or the breach of those rights had happened. This part, when it arose, is important for the purpose of calculating the limitation, because for every suit there is a limitation prescribed in the Limitation Act. Beyond that, it becomes time barred. You may have to move for condonation of delay, and if delay is condoned, that the suit is accepted for hearing. Otherwise, it will fail as time barred. Then comes the valuation. Valuation of the subject matter is for two purposes. One is pecuniary jurisdiction of the court, and number two, for payment of the court fees as per the Court Fees and Suits Valuation Act. And the last but most important part is the relief or the reliefs claimed. So this is the structure of plaint. To repeat, name of the court, description and address of the parties, facts constituting the cause of action and when it arose, jurisdictional facts, both territorial and pecuniary, valuation for the purpose of jurisdiction and payment of court fees, and relief claimed. If you miss any of these ingredients, the plaint is likely to be rejected or cause you much harm. And once you complete all these ingredients and draft the plaint, then comes the next, it is verification. Verification of plaint means that whatever you have written in the plaint is to be verified. Each paragraph in the plaint is to be verified either on the basis of personal knowledge or on the basis of knowledge or information derived from the records, or it must be based on legal advice which the plaintiff believes to be true, with a declaration that no material fact has been concealed. It means that the plaint should contain each and every relevant material fact, and nothing that may have impact on the outcome should be concealed. To recapitulate, cause of action, I said, what is You may ask, what is cause of action? So cause of action is a bundle of essential facts giving right to sue. It is a bundle of essential facts that gives right to sue or bring the suit against a particular party. The court reads the plaint, especially this cause of action part, meaningfully. If a plaint does not disclose cause of action, it will reject the plaint under Order 7, Rule 11A. So remember, the cause of action is such an important aspect of plaint that it should be carefully drafted. At this stage, only plaint is examined and defense or the written statement is irrelevant. I discussed jurisdiction and said that every plaint must establish territorial jurisdiction and pecuniary jurisdiction. This brings, and this is essential for subject matter competence. Competence of the court before whom, before the suit has been presented or the case has been initiated. Failure, if you fail to establish this territorial jurisdiction or pecuniary jurisdiction, the plaint may be returned. Suppose if a court has a pecuniary jurisdiction to entertain suits up to the valuation of 1 CR, and the valuation of your suit is ever 1 CR, then the court before whom the suit has been presented is not of the plaint. Order 7, Rule 7 of CPC provides and requires that relief must be specifically stated. Court cannot grant relief beyond pleadings, and poorly drafted prayer clause may result in incompetent degree, execution difficulties, loss of substantive rights. So, one cannot afford a poor drafting of prayer clause. Therefore, relief must be drafted with foresight and clarity. For payment of court fees. Improper valuation may lead to rejection after opportunity to correct. Order 7, Rule 11 deals with rejection of plaint. A rejection of plaint is nothing but a procedural filter. Under Rule 11, the grounds for rejection are no cause of action, undervaluation, insufficient court fees, and suit being barred by law, time barred. When a suit is filed, the court assumes that the facts as incorporated in the plaint are true and correct. Therefore, at this stage, the court examines its legal sufficiency. And if it finds that the cause of action is not properly described, it may reject the plaint. If it is found that the suit is undervalued, the party is given a chance to correct it, and failure to correct the valuation clause may lead to rejection. If it is found that the sufficient court fees has not been paid, even then, the party is allowed to correct and pay the required court fees. Failure leads to rejection of plaint. Likewise, if the suit is barred by time, then it is also rejected. We must remember as legal professional that the defendants use this Rule 11 to terminate suits as early as possible. Therefore, we as counsel for the plaintiff must draft the plaint anticipating this challenge. This requires connecting pleadings to trial. Under Order 14, issues arise from material propositions affirmed and denied. Material propositions that are pleaded by the plaintiff and denied by the defendant form the basis for settlement of issues. If material facts are weak or improperly pleaded, then issues become vague, evidence becomes unfocused, and judgments lack clarity. Thus, the result will be no proper plaint, no proper issues, no proper trial, and weak degree if the plaintiff gets success in the suit. I'll repeat that the plaint defines the battlefield. Everything else is structured combat. So as plaintiff, you have to be very careful. So what may be the practical drafting discipline? I, with my experience, may say that one may adopt the structured sequence like understand and draft material facts chronologically. Understand and draft material facts chronologically in the same sequence they have happened. Identify legal rights based on the basis of the facts you have drafted. Then identify the violation. Which right has been violated? when it has been violated. When we say when it is violated, that means that we are checking the limitation. So the first and foremost is understand and draft the material facts in the order as they have happened or occurred. Then identify the legal rights, identify the violations, and check limitation. Once you are done with these all four, then you have to check, confirm the jurisdiction. Which court has the jurisdiction to entertain the plaint you are going to draft for a relief which you want to have in favor of your client. When you are done with these five, then comes drafting of relief clause. The relief must be executable. Therefore, you have to frame the relief that is executable before the court. Now, as I said, for the purpose of pecuniary jurisdiction and territorial jurisdiction, you have to calculate the valuation of the subject matter of the suit. And now, in the last, before close of the plaint, you have to have the verification clause as is required under Order 6, Rule 15. As I said that this verification is either verification of each and every para in the plaint is to be there. No para is to be missed. We have to identify which para of the plaint is based on my personal knowledge, which para is based on documents, which para is based on information received, and which para of the plaint is based on legal advice which I believe to be true and correct. Then a declaration that nothing material has been concealed. So sloppy verification is not recommended, and I'll say that sloppy verification reflects poor professionalism. Young lawyers, for want of experience or proper guidance, or maybe that out of sheer enthusiasm, they plead evidence instead of facts. They use argumentative language, ignore limitation, fail to establish jurisdiction, draft relief vaguely, and overstate allegations. As a legal professional, we have to abide by the provisions of law and ensure that what the law requires, we fully comply that and avoid all these things. Ultimately, when we use argumentative language, ignore limitation, or overstate allegations, draft relief vaguely, or fail to establish jurisdiction, or plead evidence instead of facts, this will tell upon us only. We as legal professionals must remember that judges value clarity over ornamentation. So we may avoid ornamentation and draft the plaint, including all material facts with clarity and precision. So what I have said has layered takeaways. For UG students, They need to understand structure and logic of pleadings, build conceptual clarity. PG students must appreciate doctrinal philosophy, pleadings limit juridical power and preserve adversarial fairness. For judicial aspirants, you need to master various provisions, including Section 26, Order 4, Rule 1, Order 6, Rule 1 and 2, Order 7, Rule 1, 7, 10, 11, and Order 14, Rule 1. And you must be able to apply them to factual scenarios. Coming to conclusion, the CPC does not define plaint abstractly. Instead, it regulates it comprehensively. That legislature or legislative technique is deliberate. The plaint is not merely the beginning of litigation, it is the structural blueprint of civil adjudication. Remember, the plaint is not just the beginning of litigation, it is the blueprint, structural blueprint of civil adjudication. From institution to decree, everything flows from plaint. From execution to degree, from institution to degree, everything flows from the plaint. A good lawyer are used well, but a great lawyer drafts with foresight. Drafting is not writing, it is constructing a legal instrument that must survive scrutiny, objection, and time. That is the art of pleading. Before we disperse, I wish each one of you a very colorful, joyful, and harmonious Holi. May the festival add clarity to your thoughts, balance to your efforts, and brightness to your academic and professional journey. Happy Holi to you all. Thank you.
Thank you so much, sir. Anyone, everybody, if you have any question, you can ask now.
Someone has raised hand. He may be asked to put the question.
Yes, sir. Shubham, if you have any question, you can ask. Sir, there's a question in the chat box. I read it to you.
Please.
In which case, cost is imposed by the court upon the plaintiff in rejection of plaint or in return of plaint?
Normally not in return, but rejection.
Okay, sir. Any few more questions if you want to ask? Okay. I've shared the feedback form to you guys. You can fill this form. And as we come to the conclusion of this highly enriching session,